What really happens legally if you're pulled over in Florida and your blood alcohol concentration, or BAC, clocks in at 0.08 or higher? Here's the setup. Florida Statute 316.193 lays out the foundation. If your BAC is at or above that 0.08 mark, you're legally presumed impaired. That's called the per se limit, meaning the law doesn't care if you felt fine, cross that threshold, and you're in violation. Now, some of you might wonder, is every DUI charge the same? Not quite. See, Florida classifies DUIs as misdemeanors with different degrees, and understanding these classifications can mean the difference between being charged with a second-degree misdemeanor or a first-degree misdemeanor. Depending on your jurisdiction, a diversion can be offered for a second-degree misdemeanor. Let's break down two terms. Per se, which is Latin for by itself, and refers to automatically being over the limit, and impairment, which is more subjective. Prosecutors can use either angle to build a case, so whether you blew a 0.08 or were just weaving on the road, the law has a mechanism to ensure impaired driving is prosecuted. But how does the punishment fit the crime? Let's dig deeper. Now, picture this. It's your first DUI, your BAC sits between 0.08 and 0.15, and there are no aggravating factors. What's next? In most cases, you're facing a second-degree misdemeanor, the entry-level charge for DUIs in Florida. Here's the conflict. Even a basic DUI can come with harsh penalties. We're talking up to 6 months in jail, a $500 to $1,000 fine, and mandatory license suspension. The legal term second-degree misdemeanor may not sound severe, but the real-world effects can ripple for years. Now, you might be thinking, is there any room for leniency? Your driver's license is automatically suspended after a DUI arrest, and you have 10 days to request a hearing. You can either contest the suspension or request an hardship. Florida's courts sometimes allow first-time offenders to apply for a hardship license, meaning you could drive for necessities like work or school, but you'll need to prove real need and jump through administrative hoops. To qualify for hardship, you must enroll in a DUI class within 10 days. Let me clarify two concepts. Hardship license, think of it like a learner's permit, only for adults with a record. And administrative suspension, that's the automatic freeze of your license before a trial even happens. The resolution? For basic first offenses, there are options, but you're on a tightrope, and a single misstep can cut off your driving privileges completely. But what if you're not the ordinary case? Imagine your BAC blows past 0.15, or there's a child in the car. Suddenly, you're in enhanced DUI territory, and the consequences escalate quickly. Here's the conflict. With enhancements, penalties double. Now, you're facing up to 9 months in jail and fines up to $2,000. Plus, you'll likely be required to install an ignition interlock device, essentially a breathalyzer wired to your car's ignition. Some of you might ask, what qualifies as an enhancement? It's not just a sky-high BAC. Even a passenger under 18 inches, the car, or a second DUI, outside of 5 years can trigger harsher charges. There's no room for diversion programs, meaning you must face the legal process head-on. Let's clarify two terms. Ignition, interlock. Think of it as a gatekeeper for your car and diversion program, which in other crimes means a chance to avoid conviction entirely. DUI enhancements lock those doors shut. So, if you thought a first offense was survivable, enhancements put you at risk for life-changing penalties and no shortcuts. Now let's talk about the next step up, the first-degree misdemeanor DUI. You might wonder, how does a DUI jump from second to first degree? Well, it usually involves repeat offenses or particularly dangerous behavior. The setup. If you're convicted of a second DUI inside the 5-year window, or you commit certain aggravating acts, the charge becomes a first-degree misdemeanor. Now you're facing up to 1 year in jail and much stiffer fines. The conflict here is that first degree means a permanent criminal record and mandatory penalties like up to a year's license, suspension, and even court-ordered treatment programs. Now, you might ask, is there any way to avoid these consequences? Unlike some lesser charges, a first-degree misdemeanor DUI typically disqualifies you from hardship licenses and diversion programs. The takeaway? Crossing into first-degree territory means the system is designed to punish and rehabilitate, not just deter. It's a legal wake-up call. Finally, let's step back. What does a DUI really do to your life in Florida? Beyond the courtroom drama. The penalties don't end with fines and jail time. They can haunt your record and restrict your future. Here's the setup. A DUI conviction stays on your record for 75 years. Employers, landlords, and even colleges can see it. You'll pay higher insurance premiums thanks to SR-22 filings, a special certificate proving you carry high-risk coverage. The conflict? You lose driving privileges, and there's the very real stigma attached to a criminal record. Some folks hope to expunge or erase their DUI, but under Florida law, that's almost never possible. Now, you might ask, is there any path to restoring normalcy? Prevention is key. Avoid that first mistake, and know your legal limits. If you're facing charges, legal counsel can help you navigate, but the best defense is always not getting behind the wheel impaired. So, if you take one thing from today, let it be this. Florida's DUI system is tough for a reason because the stakes are high, both for your future and for public safety.